Camera on, unmuted for me, please.
Can you hear me?
Yes, sir. State your name for me, please.
Chad Patat.
Sir, today is the day and time scheduled for your preliminary exam. There is count one, operating while intoxicated or impaired. Third offense. Count two, carrying a concealed weapon. Mr. Kaplan, are the people prepared to proceed? Defense prepared to proceed.
Your Honor, Mr. Pat is in support to allow them to proceed via Zoom, waive the exam, and bound over to the Third Circuit Court to address these charges.
Rejoin the request.
Thank you. Mr. Tech, the reason why you're not here in person as ordered?
I have my child. I have two autistic kids. One got up this morning and I was awoke by the police, so I'm late.
Everybody safe and back at home?
Yes.
Would you raise your right hand for me, sir? Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may put your hand down. Sir, you've had the opportunity to discuss this case with your attorney, and you understand that you have the absolute right to have a preliminary examination where the prosecution would have to prove that both a crime had been committed and probable cause exists to charge you with that crime.
Yes.
And after having that conversation with your attorney, you wish to waive your right to have that exam?
Yes.
And sir, you're doing so freely and voluntarily.
Yes.
You haven't been threatened in any way or promised anything to waive the exam?
No.
Sir, you understand that if you waive the exam, the next step in these proceedings is that you will be bound over for arraignment on the information in Third Circuit Court.
Yes.
Ms. Elijah, the court will find that your client has freely and voluntarily waived his right to have his preliminary exam. I'm giving the file to Officer Ramsey for you to sign the waiver of the exam. Mr. Patak, your attorney will need to sign that form. She will sign it on your behalf as well. The prosecution will sign, indicating that they have no objection to the waiver.
No objection to the waiver.
Thank you, Mr. Kaplan.
Thank you, Your Honor.
Thank you. File is back signed as requested by the court. Mr. Patak, the court will sign as well. As indicated before, you will now be bound over for arraignment on the information, which will be 2 weeks from today, which puts us on September the 8th at 9 a.m. at the Criminal Justice Center in downtown Detroit. Your previously entered bond, which is and has been $10,000 personal, will continue along with all of its restrictions and rules. Ms. Elijah, anything else in this matter?
No, thank you for your patience this morning and thank you to your staff as well.
Mr. Patak, that concludes your business with this court this morning. Good luck to you, sir. Again, your next court date will be 2 weeks from today, downtown Detroit at the Criminal Justice Center. Have a great afternoon, okay?
Thank you.
You're welcome.
Thank you.
You're welcome, ma'am.
Here.
If you want to tell me something during it, just write it out and show me the notes. I gotta listen.
Steve, you know, she likes to switch seats. She likes you over here, Steve.
Sure. Take it.
All right, for second session, the Honorable Lisa Martin presiding. May be seated.
This is 260636 FY, State of Michigan versus Ernest Bellinger. May I have your names for the record, please?
Your Honor, good morning. Stephen Kaplan on behalf of the people.
Good morning, everyone. Jack Duhan, Neighborhood Defender Service, P number 84871 for Mr. Bellinger. Ernest Bellinger.
Thank you, sir. You may be seated. Today is the day and time scheduled for the preliminary exam. There is count one, assault with a dangerous weapon, count two, the misdemeanor of malicious destruction of personal property between $200 and $1,000. Mr. Kaplan, are the people prepared to proceed?
We are, Your Honor, we anticipate calling one witness.
Mr. Duhan, defense prepared to proceed.
Yes, Your Honor.
Any preliminary matters, Mr. Kaplan?
Not by the people.
Mr. Duhan?
There's only one witness, no, Your Honor. We won't object to the OIC being in the room.
Thank you, sir. Your first witness, Mr. Kaplan.
Thank you, Your Honor. We will call the matter. Bellinger.
Mr. Bellinger, I'm going to have you come up here, please, to this black chair that's closest to me. There's a little bit of an incline there, so watch your step. Before you take your seat, raise your right hand for me, please. Do you swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may be seated. Would you state your first and last name again and then spell them both for the record?
Demont Bellinger, BAMONCBELLINGER.
Now, Mr. Bellinger, before I turn you over to the prosecutor, my secretary sitting to my left is recording your testimony, so I need you to keep your voice up loud enough for the man standing in the back to hear you, okay? Thank you. Mr. Kaplan, your witness.
Thank you, Your Honor. Good morning, Mr. Bellinger.
Good morning.
Sir, how old are you?
53.
Are you employed?
Yes.
What is your vocation? What is your work? What is your?
Oh, social media influencer.
Do you know a gentleman named Ernest Bellinger?
Yes.
How do you know Ernest Bellinger?
He's my brother.
See in the courtroom today?
Yes.
Can you point him out to Judge Martin? What's he wearing?
Blue shirt.
Your Honor, may the rest reflect the witnesses identified in the front.
Yes, sir.
I'd like to take you back in time to Saturday, August 8th, fairly recently, that's a Saturday, August 8th, 2026. Where were you at about 9:03?
I was walking to my car, walking to the house.
The area where you were walking the car, is it a home, is it a business, is it a condominium?
It's kind of
Who lives in that home?
me, Ernest, and Marcus.
Ernest is the defendant,
Yes.
who's Marcus?
My cousin.
What's the address of the home?
41112 North Woodbury, Green Route,
In what city?
Belleville, Michigan, 48111.
On August 8th in the morning, Saturday, while you're walking your vehicle, was anything unusual happen?
Yes.
What happened that was unusual?
As I'm walking out the door, Ernest seemed to be very, very happy to me.
How far is Ernest from you when you notice that he might be agitated?
Maybe, maybe this bar, maybe,
1 foot?
yeah, I'd say about 1 foot.
What do you mean he seemed agitated?
He had a sorrow on his face. And when the video came down, he started yelling at that.
How long did he yell?
As long as it took me to open the door and walk.
Open the door of the car?
I mean, stick on
What happened if,
Unmute it for me, please.
I could see it proceed out toward my car.
what type of car were you in?
A Chevy Malibu.
How far is the Chevy Malibu parked from the front door of the condominium?
Maybe 8 feet.
What happens between you and your brother Ernest, if anything?
As I'm walking out. And as I'm walking out, I had to take a screaming thing that I continue to proceed to my car. And then he comes to the doorway. And he grabs the shovel
Talking about doorway of the home or the car?
to the condo.
To the condominium. You said he grabbed a shovel?
Yes,
Do you know where the shovel was obtained from?
on the side of, as he walking out the door, it was sitting right there on the side.
Can you describe the shovel for the judge?
It's a Chevrolet garden blade, so it has a handle, it's long and it's square,
Is it plastic, metal, or otherwise?
metal.
Well, what happened, if anything, with regard to the shovel?
He threw the shovel at me.
How far is your brother from you when he throws the shovel at you?
He steps out. And then I would say at least 3 feet.
Can you stand and demonstrate for Judge Martin his motion, defendant's motion when he threw the shovel?
Sure.
Stand up and show the judge.
So if I'm walking out and you step down, then the shovel's right here. And when he grabbed the shovel, he took it and he threw it at me like that.
Judge, may the record, have a seat. May the record reflect it was an overhand motion of the shovel?
Yes, sir.
Now, Mr. Johnson. What happened to the shovel? Did it hit you or not?
It didn't hit me.
What happened after your brother threw the shovel at you?
Once my brother threw the shovel, I grabbed a shovel. And, I took it to the window. Of the con,
Why did you do that?
because I was so frustrated and angry at what he had just done that I lost control and just broke the window.
Is there a propane tank involved in all of this case?
Yes.
Tell the judge about the propane tank.
So once I broke the window, I then began to get in my vehicle. And then that's when he came,
Who was he?
Ernest came with the propane tank. And when he came with the propane tank, and when he came around to throw it at my car, he hit me in the head with it and then it dropped and it went into the back of the window.
When he hit you in the head with the propane tank, and you do so accidentally or on purpose?
Yeah, I think that's a legal conclusion.
It's not a legal conclusion. It's a fact. He was there. Not asking for a legal conclusion. I'm asking his view as to whether the defendant did it intentionally or accidentally.
He doesn't know what someone else's intent is, that's speculation.
No, but he can base it on what he saw. He can have an opinion of what happened. That's what happens. He threw a propane tank in. Was it accidental or was it purposeful?
Mr. Kaplan, the court's going to disagree with you and sustain the objection if you want to ask the question differently.
Thank you. What part of your body was the propane tank?
My head,
How far were you from the defendant when he threw the propane tank?
it was 1 feet, 1 foot,
You suffered injury?
yes.
What injury or injuries did you suffer?
I got 4 stitches in my head.
Can you show the judge what part of your head? You're pointing to the left side,
Right.
right side of your head?
You have to say the word. You said, you need to say the word.
Right of my head.
Be more specific about the injury you suffered.
So I had to go in an ambulance to go to the hospital.
Which hospital?
Cornwall,
University. What area?
Wayne,
And what treatment did you receive for your injury or injuries?
I received the stitches.
Any pain associated with what happened to you?
Yes.
What, describe the pain?
A couple of days later, I had headaches. I had, my neck was sore. Yeah.
Judge, thank you very much.
Thank you. Your witness, sir.
Okay, Mr. Bellinger, so you testified that the morning of around 9 a.m. you first saw Ernest in the living room, was that correct?
Yes,
Okay, and that happened, you came down the stairs?
yes.
Okay, do you know where Ernest was before you saw him?
No,
Okay. Did you do anything to the living room to upset Ernest?
Objection. That would follow the conclusion. He would have to read the defendant's mind, and all he would do is describe what happened. Very similar to violence. Judge and I, maybe the mind push.
Fair enough. Did you-
Objection sustained, just so we have a clear record.
Alright, fair enough. Did you do anything to the furniture in the living room?
when,
Before you saw Ernest that morning?
Objection is the relevancy. Wouldn't justify the same.
I don't know that, is that your response to his objection?
Yeah, there's statements he made to the police about it. It's not on record, but what started it, I'm just trying to understand what happened that morning.
And whatever he said to the police constitutes hearsay. It's an out-of-court statement offered for the truth of the matter, sir, and it's irrelevant to.
The objection is overruled. You may answer the question, Mr. Bellinger, if you remember the question. He'll ask it again.
Okay, I'm sorry. Did you rearrange any furniture in the living room prior to seeing Ernest that morning?
no,
Okay, so you didn't do anything that ended the furniture?
Objection relevance, doesn't prove or disprove anything in controversy.
Objections overruled. You may answer the question if you remember the question. No, you don't remember the question, or no, you didn't move any furniture.
I don't have a question.
That's fine. So prior to the Ernest that morning, you didn't you didn't rearrange or move any furniture in there?
No,
Okay, didn't tear anything up in there?
no,
Okay, didn't stack pillows behind the door?
no,
Okay. Did you and Ernest have any verbal altercation inside the apartment?
what day?
The day we're talking about here in court?
No,
Okay, so you didn't yell anything at him?
outside,
Okay, but inside you did?
no.
Okay. So you said you were yelling outside. How long after you went outside did you guys yell and start?
He come up past the door and I got outside. That's when he said, through the door, and that's when it began.
Okay. So you were both yelling at each other outside? Yeah. Okay, is your testimony that you were actually outside when you broke the window?
Yeah,
Okay. Now, you mentioned your cousin Marcus, also lives with you guys?
yes,
Okay. You didn't see Marcus during any of this, right?
I believe he was downstairs.
When was he downstairs?
When I walked downstairs, I believe that Marcus and Mary was downstairs.
Okay. Did Marcus go outside with you guys?
Not to my knowledge.
Okay. Who owns the home that you live in?
Objection relevance,
It goes to bias.
doesn't prove or disprove anything in controversy.
What did you say?
I said it goes to the court's bias, Your Honor.
No, the last thing you just said, I thought you said something about response.
His response didn't address what I said. I don't really.
The objection is sustained if you want to ask a different question.
Sure. You knew by getting your brother arrested, he would not be allowed to return to the house you all live in, right?
No,
You did not know that.
no,
Okay, you didn't know there would be a no contact order after you called the police?
say that again?
You were not aware that there would be no contact order after you called the police?
Yes, I was made aware.
Okay, so you knew there would be a no contact order?
Objection, misstated testimony.
I didn't know it, Larry.
He learned later.
You call him.
No, he-
Okay. You, both of you already know that this court does not tolerate that. Speak one at a time. The objection's been made. Were you finished with your response?
I was asking him to clarify the answer.
I know, but there was an objection.
Well,
Did you want to respond further to Mr. Kaplan's objection?
my response to his objection is I was trying to clarify what he said because I don't think it was clear. I'm trying to make a clear record. I don't see how that's basis for an objection. I don't know why he needs to stand up and behave that way.
well, I don't need to be less than by an attorney, I say it's equal on both fronts. It's not his function to comment about me.
The objection is overruled. Mr. Bellinger, you remember the question? You may answer the question, or do you need the attorney to ask it again?
I'll rephrase it for you.
Thank you.
Didn't work. Okay. So let's just say you called the police that day, right?
Yes,
Okay. You were aware when you called the police that there could be a no contact order with your brother, meaning he could not have contact with you after that, right?
I'm not sure I was more worried about my safety than I was about what happens to him.
Well, no, that's not my question. Were you aware there would be no contact order?
Are you asking, is your question, are you saying that I called the police knowing that there would be a no contact?
Yes.
No,
Okay. And
Thank you. Any redirect?
No, Your Honor.
Thank you. Mr. Bellinger, you may step down. Thank you, sir. Mr. Kaplan, before you call your next witness, the court will take judicial notice that Mr. Bellinger testified that he lives in Belleville. He does not. It is Van Buren Township.
Yes, sir.
Your next witness, sir.
People resting.
Anything on behalf of the defense?
no witnesses, Your Honor.
Argument.
Judge, in this case, the victim suffered an injury. Injury, of course, is not required. He suffered an injury to his face, as you saw. He needed stitches. He was taken to the hospital for a while and was treated. But injuries are not required in terms of felonious assault. In this case, the unrefuted testimony is that the defendant threw a shovel and a propane tank at the victim. The manner that these objects were used, they constitute weapons. People can suffer concussions. They can suffer great bodily harm. I suppose even other instances, people like hemorrhage and stuff. But so it's not the injury of the century, but it is a felonious assault. The second count, of course, would just accompany or piggyback count one to circuit court. Thank you.
Yes, sir.
Yes, Your Honor, sorry. We object to bind over, Your Honor. Probable cause is like what there's not clear what was trying to happen with any. The long as it's all still specific intent, it's unclear what was trying to happen based on the testimony.
Anything else, Mr. Kaplan?
The court can glean through court's experience and common sense that the way the objects were used is a question of fact as to whether the victim was a victim of a crime of felonious assault. Thank you.
Court has had the opportunity to hear the witness, the victim in this case. And will find that the people have met their burden for exam purposes. Mr. Bellinger will be bound over for arraignment on the information. His arraignment on the information will be 2 weeks from today, which is September 8th, 2026 at 9 a.m. at the Criminal Justice Center in downtown Detroit. His previously entered bond with its conditions will continue. Mr. Kaplan, anything further on behalf of the people? Anything further on behalf of Mr. Bellinger?
No, Your Honor.
Thank you. That concludes this matter. Sir, good luck to you. Have a great afternoon, okay?
Guilty or not guilty, culpable o no culpable.
Sí.
Culpable o no culpable, guilty or not guilty.
Ma'am, what are you here for? With the pink tank top on and green glasses, what are you here for?
I'm
You're
here
here-
on behalf of DeVoe King.
What do you mean behalf of?
He asked me to join for support.
Thank you. You're an observer, is what you're saying.
Yes.
Thank you. Thank you.
Yeah. No. It's gonna be on Zoom. Yes. Okay. Right. Then came here. Is the MVOC, is that here about it?
Mhm.
Oh,
I'm just waiting for Mr. Lucky to be available.
I'm sorry, Judge, I'm in both courtrooms, but I am
Stan,
ready.
as soon as you turn your camera on, I know you're ready and we'll call the case.
All right, here we go, Judge.
So then will my,
This is 260391 SM. This is State of Michigan versus DeVoe King. May I have your names for the record?
Good morning, Your Honor. Jacob Lecky appearing on behalf of the people, P88400.
Mr. King, camera on, unmuted for me. Please state your name.
Can you hear me, Your Honor?
Yes, sir. I just need you to state your name, please.
I've said it 3 times, DeVoe King.
Oh, it didn't come through.
I apologize.
No worries. Today was the day and time scheduled for the final pretrial in this matter. This is the deadline for any plea in this case. The court is in receipt of a document called File for Dismissal 260391. Mr. Lecky, have you received this document?
I have, yes, Your Honor.
Thank you. Do the parties need an opportunity to speak in a breakout room before we proceed with today's final pretrial?
That would be up to Mr. King, Your Honor.
If we are filing dismissal, no. I have no reason to speak.
So, Mr. King, the motion was, or it's called File 4, which the court is taking as your motion, although it's not signed by anyone. There's no indication of who filed it. And there's notice provisions that must be maintained in terms of a motion being heard.
I do not have those accessibilities. I have tried to have a lawyer help me with all that, and none of them are willing to help me unless if I have $5,000, which I do not have at the moment.
Understood, Mr. King.
Filing as best as my abilities.
You're fine. It was received, it's in the file. Mr. Lucky's confirmed his receipt of it. The issue is he has time. Mr. Lucky is provided or allowed time to file a written response to the motion. If he wishes to do that, the court will take the motion up before the jury trial starts on September the 21st. That's why I have the parties come at 8:30 and the jurors come at 9 o'clock. If we need to take up the motion at that time, unless Mr. Lecky is prepared to argue the motion right now.
Your Honor, I can argue it right now.
Oh, Mr. King, it's your motion. Please proceed.
It is okay. So I have to argue my point.
Yes,
at the
sir.
top? Okay. So based on receiving discovery, it is clearly obvious that both parties are lying. Neither of their stories matches up, and neither of their stories matches up with the truth in any way, shape, or form.
Who are the both parties that you're referring to, sir?
Christy Perry and Diami Bomia.
Was there any other argument you wanted to make regarding your motion?
At this time, no, ma'am.
Thank you. Mr. Lecky.
Your Honor, just based on defense's resuscitation and defense's motion, I think those are questions of fact for a finder of fact, and I think that's what the jury trial is here for. So I think this is still ripe, so I think we should just move ahead to the jury trial.
Anything else, Mr. Lecky?
No, Your Honor, thanks.
Anything else, Mr. King?
No, ma'am.
Thank you. Court, having had the opportunity to hear the argument of both Mr. King and the prosecutor signs this matter, the request to dismiss the case is denied. Mr. King, it is accurate that the trier effect in this case will be jurors selected by the parties on September 21st. They are in the best position to judge the credibility of any witnesses and or any witness statements. This court has not received, does not review the discovery, so this court is not in a position to evaluate the sufficiency of the claims made by the witness and the alleged victim in this case. The motion is denied. We are scheduled for trial on September the 21st with you to be here at 8:30. The jurors are here at 9 o'clock. We will commence the trial properly at 9 o'clock. The parties proposed witness lists, exhibit lists, and jury instructions are due to this court by 3 p.m. today. That was reduced to writing and mailed to the parties after our last court date. Mr. Lecky, anything else in this matter this morning?
No, Your Honor, I have all of those things besides the exhibit list is the last thing I'm waiting on. Those will be sent by 3 p.m. today per that order. I just wanted to clarify and just make sure, absolutely sure that for the record indicates I have sent all discovery to the email that defendant has, and I also have filed.
Objection, Your Honor. I have not received.
Hold on,
video
Mr. King.
discovery.
Mr. King, let him finish speaking. Mr. Lecky?
So the discovery was sent to the email that the defendant forwarded his motion to this morning. So I sent that the day of our last meeting. Let me pull it up because I want to be accurate. 8/11/2026 is when they were sent to that email. It's the same email he sent his motions to, Your Honor. Or sent his
Anything else, Mr. Lecky?
No, thank you, Judge.
Mr. King, what was it you were trying to say, sir?
I have not received the video discovery. The only thing I received additional to the paperwork was a Trojan horse to try to hack all of my phone records.
Your Honor, if I may.
Wait a minute. Mr. King, was there something else you wanted to say, sir?
No, that was it, Your Honor.
Mr. Lecky?
Your Honor, so I think the link, what he's talking about is the Axon link from evidence.com. That's the only way that we send discovery. That is sent. I sent it. He just acknowledged receipt of it. That is for the digital discovery. There's no other way to send it. So that's how it comes.
Mr. King, is the thing that you're referring to as a Trojan horse, was it a link inside the email from the prosecutor?
No, ma'am. It was all of the things that came additional to me trying to download that, and I had to delete everything from it because it was literally hacking my entire phone.
After receipt of that link with the digital discovery on August 11, did you reach back out to Mr. Lecky and advise him that you were having any difficulty in accessing those video files?
I had not.
Okay.
I did not know that's what I needed to do with this court proceedings. This is completely different than anything I've had to deal with. Usually it would have been dismissed long ago.
Mr. King, if you don't communicate to Mr. Lecky that you can't access it and the court was not made aware of the fact that there was a failure of the discovery, there's nothing the court can do. But now being aware that you cannot access it, Mr. Lecky, how do you propose to get the discovery to Mr. King to allow him to review it before September 21st?
So, Your Honor, I have my constitutional obligation extends to sending it. However, I would also be available to have the defendant come to our office to meet, or to the, where is this, out of Sumter? So possibly, I can't remember if it's Huron Township Police Department that Sumter runs out of, or one of the police departments. I would have to meet with him at one of those times. However, that would be really limited availability, but I would make that.
My availability is going to be questionable at the moment. I literally just got a job this morning. That's why I was running a little late to court. I was having my interview.
No worries, Mr. King. What I would suggest is that you have each other's contact information. If you're
Mhm.
able to arrange something to either view the videos, meet somewhere for an exchange of what it is that you need to see the videos, great. If not, again, you're due here at 8:30 on the 21st of September. If you want to spend that time in one of the conference rooms here on the second floor, you can review the video at that time. How long are they, Mr. Lucky? Do you know?
Your Honor, both videos are a total of, so one is an hour and a half, the other's 2 hours. Granted, maybe only a total of 2 hours is substantive. So it would have to be done, and I would like to, if possible, I can meet in the breakout room and pick a date. I don't want to not have a date set before we leave. So that way it can be placed on the record and we can have that set for the court.
So that's what, Mr. King, please extend.
Sorry, Your Honor, you got cut off mid-sentence. What was that?
No, I need you to go in with Mr. Lecky to pick a time, a date, if possible.
See, that's what I didn't hear, Your Honor.
It's okay. Let's move you again. Oh, I thought that piece had been repaired, but it's just fallen off.
Oh. Yeah, I still see something kind of like hanging there.
It just won't look up there.
No.
Have they arrived?
We don't know.
Okay. Are you supervising Lewis or are you handling Lewis?
Like that, just keep, see, do we know if they're way?
They're not here, so I'm hoping on the way.
No, she unfortunately fell ill, so I'm going to take this over.
When they arrive, do you need to speak with him before we begin?
I'd like a couple of minutes to speak with them.
So I'll let Officer Ramsey know that when he gets here and they get him situated to put you in the hallway with him, and they'll let me know when you're ready.
Sure.
Thank you.
All right, we're back, Judge. Sorry.
No, he's not. Hold on one second.
Oh.
Parties
back.
are back from the breakout. Have you agreed upon a method to exchange this information?
Yes, ma'am.
Yes, Your Honor, sure. We did have a breakout discussion in which, I indicated, as I did on the record, my obligation only provides to providing discovery. I indicated times, or I indicated venues in which we would meet. The defendant refused to meet in person because that's the only way I can show him these things. The only other alternative were me to try to send the videos via the link again. And that is the alternative in which this defendant has accepted. So I'm going to attempt to send them again in hopes that they're sent. Or hopes that he has viewed them. Because we do already have receipt. He has already admitted to receipt. So that's where we're at, Judge.
Is that an accurate statement, Mr. King, as far as how the information is to be transmitted?
Yes, ma'am.
Anything else for me this morning, Mr. King?
Not this morning, Your Honor.
Then, Mr. Lucky, anything else?
No, thank you, Judge.
Then that concludes this matter. I will see you on September the 21st, 8:30 a.m. Everyone have a great afternoon. Mr. King, good luck with the job, sir.
Thank you.
You're welcome.
Have a wonderful
you.
day, Your Honor.
You too. Thank you, sir.
I don't think it already has an exam date, so because he wasn't arraigned. So, Madam Clerk, what do we have available? He's in custody and he will be for a while.
Yes, we have to do it.
So expect for the most lubrication they got. What's interesting about this case, as soon as it's this statute. 6 years ago. I know. Anyway. Yeah, I mean.
No, can you hear it? Perfect. That's, yeah, it's unreasonable to tell prosecutors. You wanna know how? Yeah, when you're doing. When? Oh, okay. Why did I not join it? Yeah. Oh, they don't, I didn't do. Oh, that's big. Do you have to keep checking with one of my supervisor? Mary Bob, my supervisor? Nick, Happy Way, you were the host. No, I ain't not the prosecutor's office. Not years. 2 years. I've been in my training for years. No, or I've been a 3 years. I have this thing about looking at people. That I mean, I don't believe, I believe in bad circumstances, I don't believe bad. I know that sounds weird, so, but was so, what? What is? I always believe, and you know, when I said when the prosecutors talk about what people are. You didn't like that people, that's not what.
Well, that should be the upbringing.
I mean, I understand people go through bad circumstances, I don't believe in that.
But there are some people who are.
There are.
Before me.
There are. I just did a whole, I did a tape with a guy with the wrong media.
Find out.
Mr. Briggins?
Yeah.
Ready, bring him right out.
Judge wants.
Wait, who's he?
No,
there. Oh,
there.
it's on record.
Let me have.
No, Louis is gonna be a dismissal.
Do you want to do it?
Yeah, but Judge wants to stop.
Already got him.
Yeah, Judge, highly suggested.
Thank you.
Would you have never said?
I just didn't want to open the door to their congregation. Once I do that, this happened 3 years ago, 3 years. It's really helpful. Now, I know, and before I should have enjoyed one. Yeah. The other one was Casey. Oh, my.
Very much.
Carrie Marks.
See it already?
Absolutely.
Okay, we need to bring them in.
Yeah, you know, when you tell a client that no one's here for a case, they suddenly don't really want to talk that much. Let's go. Starts with attitude. So that was his word. Teachers first. Teachers first.
One of my favorite ones.
Like waiting.
So, yeah,
I'm old enough to do that.
yeah, I like when he gained extra yards.
Yes, like that you are, absolutely. I remember that.
He wouldn't make it case to the still.
You what?
You John the Reeves, right?
Yeah, you couldn't bring it down, but. Yeah, but I didn't, I mean.
It's not like that for me.
So I don't want to, but they. Good job. Okay.
Yeah, that is.
Keep your.
Good line. It feels like you're a fishy.
You know. And. I was in
I
charge.
just know I had good parents on luck.
Yes. And that's, you know, I kept me out of trouble, kept me pushed, I played sports, so. I like to be, so.
My parents insisted, they said, you're attending college. I was held in the media. And that's. The homes is about equal. Oh. Eric, they deep. It's not easy. You know, I eat it.
Court session, Honorable Lisa Martin presiding.
You may be seated. This is 240689FY. This is State of Michigan versus George Lewis. May I have your appearances?
Thank you, Honor. Stephen, if you have one, you can get it.
Hey, good morning, Your Honor. Good morning to your staff. I'm here with the service back in 82125 on behalf of Mr. George Lewis, who stands to my right. Mr. Lewis, can you state your name for the record, please? George Lewis.
Thank you, Mr. Lewis. You may be seated. Today is the day and time scheduled for the preliminary. In this case, there is count 1, possession of methamphetamine, count 2, carrying a concealed weapon, count 3, carrying a concealed weapon, count 4, felony firearm. Mr. Kaplan, are the people prepared to proceed?
Your Honor, in this case, which occurred in 2020, Trooper Martinez was the main person, main officer involved in getting the evidence and making the traffic stop. He is not here. We did subpoena him. We'll have no excuses for his absence. I can speculate as to why he's not here. Might be that he heard Mr. Riggins cross-examine him, but at any rate, we're not able to proceed.
Your motion.
Yeah, and I move for dismissal, and I actually move for dismissal with prejudice. This is a matter that the date of incident was July 26th of 2020. As such, refile will put it past a 6-year statute of limitations.
It's really of no consequence because we're not going to reauthorize. If we do, though, affirmative, the sexual limitation comes to an affirmative defense. And if we can show that the defendant was outside the state for 30 or more consecutive days would be told. So I'm not sure that the judge should reach that ruling. I don't think it's necessary in this case.
The defense motion to dismiss is granted. That dismissal is without prejudice, but Mr. Riggins, you've heard Mr. Kaplan make the assertions that the people will not be refiling. And if they do, you make your affirmative bench heard. Anything else, Mr. Kaplan?
No, thank you very much.
You're welcome. Anything else, Mr. Riggins? Thank you. Mr. Lewis, that concludes your business with me. Good luck to you, sir. You're welcome.